Joining us tonight is Robert Ray, a member of the President's defense team, former federal prosecutor, independent counsel for the Whitewater investigation. Ray, great to have you. Robert, it's great to have you with us. Let me start.
Nice to be with you, Mr. Dobbs, this time from D.C.
You're working hard for the President's team. I was taken today by Pat Cipollone's comments, and I'd like to play this for the audience as he addressed the issue of the delays in getting these articles to the Senate. If we could hear that, please.
They held these articles for 33 days. We hear all this talk about an overwhelming case that they're not even prepared today to stand up and make an opening argument about. That's because they have no case. Frankly, they have no charge. When you look at these articles of impeachment, they're not only ridiculous, they are dangerous to our republic.
I just don't think that expression could have been framed better, more eloquently than Pat Cipollone just did in that soundbite. Your thoughts?
That's the right argument, isn't it, Lou? I mean, look, it's first that Speaker Nancy Pelosi held the articles of impeachment hostage, and now the Democrats in the Senate, with the aid of the House impeachment managers, are attempting to delay the inevitable, which is the start of trial. So we're now on our third procedural motion with more hours of debate that consumed the entirety of the legislative day today before the United States Senate. And it's not clear to me that that will be over even today. So I'm anxious. I'm preparing. That's why I'm here.
Right.
I'm actually excited about the prospect of getting started because that's what the trial of an impeachment is for. But I don't see how delaying through procedural mechanics what is inevitable and the start of this trial really is in the country's best interest, and I don't even think it's in the Democrats' best interest.
Well, it's sure as hell not in the country's interest. It's certainly not in the President's interest, and that makes it irrelevant whose interest it is in after that, because this is an obscenity that should never, ever have gotten, in my opinion, to this point. And I'm delighted that you and the other members of the President's legal team are making that so clear. I want to turn to the issue of executive privilege as well. The President's attorney, Jay Sekulow, today saying this about the Constitution.
This is not some new concept. We don't waive executive privilege, and there's a reason we keep executive privilege, and we assert it when necessary. And that is to protect the Constitution and the separation of powers.
Sekulow speaking, among other things, to the issue of whether some witnesses would be brought forward without constraint from the executive branch and from the President of the United States. Your thoughts?
Look, presidents of both parties, Lou, have asserted executive privilege. It is particularly of importance in connection with matters involving foreign policy and the confidentiality of advice that is provided to the president at the highest levels. That should not be a surprising concept to anyone. And of course, in the House, Democrats had the choice about whether or not, in the face of an assertion of executive privilege, should they desire to challenge it, to go to court and litigate that issue fully, right, to get a final decision there, to proceed once that final order had been obtained. And they chose not to do that because they found and stated that this was so pressing and such a matter of national concern that they had to speed along the articles of impeachment, only to have Nancy Pelosi then, for partisan advantage, hold them up for a month in order to extract attempt to extract procedural concessions in the United States Senate, which even today they're still trying to do, and which will not be successful.
And in the throes of their absurd reasoning, they also, of course, had to protect their argument that the president would somehow be obstructing justice if he were to resort to the courts to protect executive privilege. Their madness went on and on. This is from White House spokesman Hogan Gidley today, who said this. If we could have this full screen up, because it again goes to the issues that you're going to be confronting tomorrow. He said, The man Democrats appointed to lead these proceedings is Adam Schiff, who has been caught lying multiple times about Russia collusion evidence that didn't exist, made up a totally phony phone conversation about Ukraine that never happened, and lied that his staff didn't have contact with a whistleblower. If there's anyone who should be disqualified from leading this proceeding, it's Mr. Schiff. Is disqualification of Mr. Schiff on the agenda of the legal team?
Look, I don't think, honestly, that any of those things, including the Democrats' latest effort to try to disqualify Pat Cipollone from the legal team, and then there's other efforts underway in unrelated proceedings about trying to have the Attorney General of the United States recuse himself in connection with the Las Parnas investigation. I mean, it seems like now the default position with regard to anything in which there's a contentious issue is to ask the decision maker to step aside. We can't run a country that way. I don't really think that's the path forward. I am anxious to have a trial. Let's get to the shooting match.
And that's getting underway in earnest tomorrow. And shooting away will be Robert Ray. We thank you for being with us, Bob. Thanks so much.
Thank you, Mr. Dobbs. Always a pleasure.